Hello students, welcome to third part of ninth history lesson number 6, Empowerment of Women and Other Weaker Sections. In the second part, we have learnt about women empowerment struggle, law for women, family courts and trial involving alimony. Today we will proceed with the Commission of Sati. Sati Prevention Act. The incident of Sati by Roop Kanwar on 4th September 1987 created an uproar. First of all, Sati. What is the meaning of Sati? The Sati was a historical practice found chiefly among Hindus in the pre-modern regions of South Asia in which widow sacrifices herself by sitting atop her dead husband's funeral pyre. A pyre means is a structure. Here we can see this picture. A pyre means, see here, a pyre means is a structure usually made of wood for burning a body as part of a funeral rite. As a form of cremation, as a form of cremation, a body is placed upon or under the pyre, which is then set on fire. So Roop Kanwar was a woman who was burnt alive at Devrala village of Sikar district in Rajasthan, India. At the time she was 18 years old and had been married for 8 months to Malsingh Shekhawat, who had died a day earlier at age 24 and had no children. She did not do this on her own but was forced to do it. Meera Menon, Geeta Seshu, Sujata Anandan, Anu Joseph, and Kalpana Sharma investigated the case. So, after the investigation, it was revealed that she did not do this on her own but was forced to do it. More stringent provisions were made in the Sati Prevention Act in Government 1998 passed by the government. Means if any person forces or commits sati either directly or indirectly shall be punishable with death or imprisonment for life and shall also be liable to fine. Human Rights Protection Act. Human Rights Protection Act was enacted in 1993 to prevent injustice to men and women. The purpose of forming Human Rights Protection Act was to protect the rights of citizens of the country. Like there have been several examples of rights of people being waived off due to some individuals in government like politicians, also by government officers and during giving justice by the judiciary. In this case, Human Rights Protection Act intervenes and proceeds in maintaining and preventing the rights of people. National Human Rights Commission and the State Human Rights Commission was established in some states. Following the central government, state government also formed Human Rights Protection Act so as to protect the rights of the people in the state. This law played active role in mitigating injustice dealt to women. Mitigating means making less severe. So also human rights of the women were at the stake. So in order to give justice and protect the rights of the women, citizen of the country, Human Rights Protection Act actually participates in protecting women rights. Come to the next point. Reservation of women. Women has always been seen suppressed by the male dominance in the society throughout the world. In order to enable women active participation in upliftment of the country, various researches and many more productive places for women participation was found to be necessary. So Government of India passed a bill in the 73rd and 74th Constitutional Amendment 1992 that provided reservations of one third. The 73rd and 74th Constitutional Amendment Acts enacted in 1992 provide reservation of one third seats and offices for women in Gram Panchayat, Panchayat Samitis, Jilla Parishads, municipalities and municipal corporations, as well as for the post of Sarpanch, Chairman and Mayor. It provides opportunity to participate in business to women. This resulted in upliftment of women empowerment in the country. Next point, provisions in constitutions and laws. In the post-independence period, the Constitution of India accepted the principle of equality of men and women. Women got equal rights and could work on par with men. Inhuman practices like Sati, dowry, and polygamy were banned by law. The process of liberation of women has gathered momentum. In the post independence period, the Constitution of India accepted the principle of equality of men and women. Hence, women got the important political right to vote. Women got equal rights to education and work on par with men. Par with men means equal in importance with men. Inhuman practices like sati, dowry, and polygamy were banned by law. Women's right to sue for divorce was recognized. They got a lawful share in property. In local self government bodies, seats were reserved for women so that they would have their just share of political power. We see today that due to these provisions, women have begun to get education and to earn. Also, due to ideas of women's liberation, women are developing a sense of self. They have begun to participate enthusiastically and with determination in all fields of education, earning money, administration, politics, etc. Scheduled castes. The erstwhile means former or past, untouchable castes have been recognized as the scheduled caste. Untouchability was abolished by Article 17 of the Constitution. They were given reservation in education and public employment, etc. Thus, special provision have been made for their welfare and development. In the post-independence period, our constitution adopted the values of freedom, equality, fraternity, and social justice. In accordance with his, the practice of untouchability was banned by law. Untouchability was removed by the 17th paragraph of the Constitution, and this class was included in the scheduled castes. In view of the educational and social backwardness of these castes, they were given reservations in education as well as jobs to facilitate their development. Next, scheduled tribes. The Adivasis are the weakest section of the Indian society. These have been recognized scheduled tribes as they live in forests and on hillsides. They do not have any means of livelihood other than agriculture. They are malnourished, poor, and do not get proper medical attention. They are given representation in law boards, education, government services, etc. Scheduled tribes, just like the scheduled castes, the scheduled tribes or Adivasis who live in remote parts of the country also face several difficulties as they have lived far away from the progress made in modern times. They are economically and socially backward. Even though their conditions have seen some improvement in recent times, they do not have any means of livelihood other than agriculture and forest produce. Modern farming implements have not yet reached them. Hence, their income from agriculture is very small. Besides, their fields are on hillsides and not fertile. They are malnourished due to insufficient and poor quality of diet. Adivasis in remote areas find it difficult to get medical attention in time. For all these reasons, there is a need to give special protection to Adivasis. In the Indian Constitution, Adivasis have been enumerated as scheduled tribes. They are getting given representation in law boards, education, government service, etc. Next one, nomadic and denotified tribes. A number of tribes who move from place to place for their livelihood and engage in rearing animals are called nomadic tribes. A number of nomadic tribes were declared as criminals by the British in 1872 and ban was imposed on their occupation and movements. This unjust law was repealed in the post independence period and curbs on them were lifted. They are included under denotified tribes. Special provisions are made for their welfare. Nomadic and denotified tribes. Castes and tribes that move from place to place for a livelihood are included under nomadic tribes. They live by rearing animals and engaging in some other occupations. The British had declared some of them as criminal tribes. In the law of 1871 to curb crimes, some of the main groups were mentioned as criminal tribes and their occupations and movements were banned. This unjust law was repealed in the post independence period and the curbs on these tribes were lifted. They were included under denotified tribes. Special efforts are made by the government for the purpose of their social and economic development. These tribes have been given representation in educational institutions and the government sector. And now last one, minorities. A group of people of particular religion, language or race which is smaller in number is called a minority. There is a diversity of religions, language and culture in India. To preserve this diversity, the Constitution has given educational and cultural rights to the minorities. Minorities have the right to protect and conserve their language, culture, and traditions. For this purpose, they have the right to set up separate educational institutions. The government implements various schemes for their progress. Minorities. So that means in any society, a group of people of a particular religion, language, or race who are few in number are termed a minority. As there are various religions, sects, and languages in our country, we see great cultural diversity there is variation in cultural traditions too. In order to preserve their cultural traditions and, and develop their own language, the Constitution gives the citizens certain educational and cultural rights. Minorities have the right to protect and conserve their language, culture, and traditions. For this purpose, they have the right to set up separate educational institutions. The government implements various schemes for their progress. In the next, in the for their progress. So, students, today we have learnt about Sati Prevention Act, Protection of Human Rights Act, Reservation for Women, and about other weaker sections. So, students, I hope you understood the lesson. Thanks for watching.